first matter before the court is Jeremiah Hogan versus Lincoln Medical Partners. This is Lincoln 24209. Counsel appear to be present, and I'm going to ask that you identify yourselves by saying your names for the record, starting with the appellant.
My name is Jenkins, and I represent the appellants in this matter.
Good morning, Your Honor. Joe Mavodones on behalf of the appellees.
Thank you. I hope we're being streamed live on the web. I know we've had a few technical difficulties here this morning. But with that, if you are ready to proceed, Mr. Jenkins, we'd be happy to hear your argument.
Yes, Your Honor, and may it please the court. The Superior Court erred fundamentally when it held that the PrEP Act immunizes medical professionals and medical practices that administer emergency use authorization products to Maine's minor children in primary school settings without parental consent. And it erred further when it invoked the doctrine of constitutional avoidance rather than addressing the immediate and profound constitutional implications of its decision. It could be argued, speculatively but reasonably, that in adopting its maximal interpretation of PrEP Act immunity, the Superior Court has actually undermined the purposes of the PrEP Act by undermining the entrenched and constitutional rights of Mainers to consent to medical interventions, or to put it another way, their right to reject medical interventions and refuse them, and the rights of Maine's parents to the care, custody, and control of their children. By undermining these rights, ironically, the Superior Court may have stimulated the type of vaccine hesitancy that the PrEP Act seems designed to have addressed. This court is reviewing de novo an interpretation of a statute, and in doing so, it must start with a look at the plain meaning of the statute at its text. 42 U.S.C. Section 247D-6D, which is the PrEP Act, does grant immunity for covered persons that are administering covered countermeasures. And the appellees in this case, as a basis for their argument that these are administration, that the right to consent is a feature of the administration of an emergency use product. That, however, is not the case. And we know it's not the case because the PrEP Act is hardwired with the emergency use authorization statute. It refers expressly to it. There's connective tissue linking these two statutes. And we see that in the definition of covered countermeasure, which can be found in 42 U.S.C. 247D-6D I1. And this definition refers out to the emergency use authorization statute. That statute states that products that have not been licensed by the Food and Drug Administration may circulate in commerce and be used in the marketplace only if the Secretary of Health and Human...
Counsel, I see that the green light is on. I understand the argument you're making, and I don't suggest we always follow everybody else, but are there any cases supporting the interpretation that you are urging upon us? There seem to be plenty supporting the other side.
Your Honor, one is swimming upstream. That has to be acknowledged. On the other hand, all of the cases cited in the briefing, cited by the Superior Court below, have something in common, and that is that they haven't made the arguments we're making here today. They actually haven't considered the interrelationship between the emergency use authorization statute and the PrEP Act. And that's what I'm inviting the court to do today, and that's the conversation I'd like.
I think in a very purposeful way that the vaccine is not a covered countermeasure for the purposes of the statute here.
Your Honor, I'm arguing that in order to be a covered countermeasure, the Secretary must have taken steps to ensure that those using it were properly informed of their option to accept or refuse administration. That's the language of this statute.
So you're centering that on the Secretary needs to establish some process by which authorization, opt-in, opt-out takes place, and that was missing, and therefore the vaccines are not covered. Missing, and therefore the vaccines are not covered countermeasures? Is that what your argument is?
The argument is slightly different. It's that there is a right to accept or refuse this countermeasure. That right exists. The Superior Court acknowledged it. The appellees have acknowledged it. But the argument they've made is that the right exists, and if you can't bring a lawsuit for civil money damages to enforce the right, that's of no moment, because the right still exists.
The right, let me just back you up. What right still exists? The right to sue for medical
the right to
malpractice?
consent or refuse the product.
So is that suit against the Department of Health and Human Services? I mean, they're the ones that, in your argument, messed up and didn't put in the authorization process. The providers here were not part of that mistake. Wouldn't your claim be better focused upon and brought against the Department of Health and Human Services?
Well, Your Honor, the argument isn't that the process wasn't in place. That it was in place, and in fact, the appellees did, to some extent.
So the Secretary did establish conditions on the authorization?
There were conditions on the authorization,
Okay,
which he established through a number of declarations.
All right.
I mean, the PrEP Act clearly doesn't abolish the right to refuse the treatment.
Not expressly, but it does vitiate the right. It hollows out the right. It's
So
not.
what you're saying is you may still have the right, but there's essentially no realistic way to enforce it.
It's meaningless. It's not worth the paper it's printed on if you can't enforce it in a lawsuit for civil money damages. And there is a constitutionally protected right and interest in ensuring access to the courts. And this
There are a lot of different immunities scattered throughout the law. The fact that there is an immunity by statute doesn't necessarily mean that the right to access the courts is been vitiated.
No, although the immunity mentioned by the appellees in their briefing was sovereign immunity, and that it's different because the momentum in sovereign immunity is with the state.
There are clearly other immunities.
There are other
besides
immunities.
sovereign immunity.
Yes.
What you're complaining about is that there's a limitation of liability when there hasn't been consent. And haven't we said in at least 2 cases that pursuit of a negligence claim is reviewed under a rational basis analysis because it's not a fundamental right? And if we adhere to that, doesn't this statute meet the rational basis test?
Your Honor, the fundamental right at stake here isn't the pursuit of a negligence claim. It's actually, all these claims are heavily imbued with other constitutional import. So we have a fundamental right to bodily integrity.
No one is saying that you can be vaccinated against of liability.
Well,
and that has been, we've deemed that pursuit of a claim, it's like a cap on damages. And haven't we said in that context, it's not a fundamental right?
Well, there's an entire class of claims that are being extinguished. It's not just a cap on the amount of damages or some other type of modification to the contours of the procedure. Our clients' claims are being extinguished.
But that's what Congress intended to do. Congress enacted this really very affirmative statute with a bullet point list. It's like, wow, okay, they've really narrowed it down.
Yes, Your Honor, and this is exactly the point I was attempting to make when I referred to the EUA statute, because that statute says that a covered countermeasure is one to which a person has the right to accept or refuse. And that right is being vitiated with this expansive...
Well, the problem is really that the remedy for violation of the right has been essentially vitiated. It's not really that the right has been.
But then this is...
I understand.
Yes, it's an interesting argument, but without a remedy, what is the right?
Except that the right isn't entirely eliminated because there is a remedy should it be serious bodily injury or death or willful misconduct.
And should it not be one of those, then there is no remedy. My clients have no remedy. They have zero remedy, given the Superior Court's interpretation. And I think that's interesting. And as I said in my opening remarks, is that really what Congress intended when it enacted the PrEP Act, that it would strip a whole class of citizens who did not consent to the administration of these products on behalf of their children of their right to sue?
Just to be clear, are you saying that this is not a covered countermeasure under PrEP? Did I hear you correctly? Are you suggesting this does not fall within the definition of
No.
a covered countermeasure? You're conceding that this is?
I am conceding that it is a covered countermeasure. That's definitely the case. But what I am saying is that the immunity only applies if the right to accept or refuse is honored. And if you look at the scope provision in the PrEP Act, so Congress took the time to delineate the immunity. It actually gave us a list of things that are included within the immunity. And it says that it has to be a claim for loss that has a causal relationship with a series of things. And consent is not included among those things. Even though it's an entrenched constitutional right, it's entrenched in our common law, that one has the right to accept or refuse. This court has found repeatedly that that is an ingrained, inculcated right.
So if you,
fundamental right that we talk about here is the right to bodily integrity, but hasn't our jurisprudence already limited that to adults?
I don't know that there is a distinction between children and adults when it comes to the right of bodily integrity, Your Honor. And parents, I think, have standing to assert that right on behalf of their children in the form of giving or refusing consent to medical care. There's a fundamental right that parents have to the care, custody, and control of their children, and exercising that right, they make medical decisions on behalf of their children.
Thank you.
Thank you.
Mr. Mavodones?
Good morning, Your Honor, members of the court, may it please the court. In this appeal, the appellees asked the court to affirm the trial court's decision on the motion to dismiss the pending notice of claim. In this appeal, the primary issue involves one of statutory interpretation. And we ask the court to interpret and apply the PrEP Act according to its plain meaning and consistent with numerous other jurisdictions, both state and federal, in their interpretation and application of the PrEP Act. And as you know, the PrEP Act provides immunity to certain covered or qualified persons. It makes those persons immune from suit and liability under state and federal law for all claims for loss that are either caused by, relating to, resulting from the administration of a countermeasure. And in this case, we know that there was a declaration issued by the Secretary in March 2020 that each appellee is a covered person under the PrEP Act. And therefore,
The green light is on, so I'd like to explore the issue of the constitutional avoidance issue. If someone is arguing that a statute is unconstitutional, how can we avoid addressing that issue?
right, and I think, Your Honor, under the court's sort of statutory interpretation framework, under the rules of construction, the court will presume that a statute is constitutional, that it was passed by the legislature to be constitutional. And if this court can construe it in a reasonable way, that makes it constitutional.
Well, that is a way of addressing the constitutional issue. In other words, if somebody raises the issue that a statute is unconstitutional, if we construe it in a manner that we say meets the Constitution and renders it constitutional, you are addressing the constitutional issue. You can't not address it.
Well, correct, Your Honor. I think you can look at it and determine if it can be interpreted in a way that passes constitutional
But didn't the
law.
Superior Court below just said, I'm not going to address this, I've interpreted it provides clear immunity? That's
Yes,
what
Your
the
Honor, I
statute
believe that
says.
the trial court interpreted or applied, looked at the notice of claim and said there were no constitutional claims being presented, and therefore did not address the constitutionality issues.
But looking at the big picture here, I think most people would sympathize with the plaintiffs and say, your 5-year-old child had an organic compound injected into his body, which you would not have approved, but it was done anyway, that a wrong was done there. We have the act, the PrEP Act itself, which would seem to immunize everything, but as was just been discussed here, if there is in fact a constitutional right to bodily integrity, how does this statute not fly in the face of that, based upon what happened here with this immunity being applied to the wrongdoer?
Right, Your Honor. So I think the constitutional right at issue would be the liberty interest,
Of the parent?
yes, of the right to make medical decisions about.
Yes,
minor.
yep, and where does that take us?
Where I think the court would then look to the PrEP Act to see if there were, under the rational basis review, are there state interests that support Congress's intent to enact this statute and provide.
And your position, there is in fact a rational basis, which was the crisis created by the COVID pandemic?
Well, yes, and I think the PrEP Act was actually, I think it was discussed in the appellant's brief, the sort of statutory scheme came about in the early 2000s to apply to any kind of public health emergency that could arise. I think there was a prior case, we cited Parker, that involved, I think it was a smallpox outbreak in New York. But it was the same thing. It was a public health emergency that was declared, and I think it's page 52 of the appendix, or starts on 52, page 850. It's the first declaration issued by the Secretary, which addresses in there, sort of one of the bases for enacting the declaration was that, let me get the exact language.
So you're offering up a rationale for a rational basis?
Exactly, yeah. So the declaration stated that the declaration was issued in order to have a sustained, coordinated, proactive response to the COVID-19 outbreak.
The rational, the rational basis test is a well-known, fairly easily met test. If the constitutional interest here at stake is a parent's liberty interest in making medical decisions on behalf of the child, why isn't that a fundamental interest that deserves a higher level?
I think it could, but I think in this case, the PrEP Act would still pass that because the Act allows the declaration that's issued that triggers immunity to be tailored to specific timeframes, to specific geographical regions. And in this specific case, it was obviously a nationwide enactment under the declaration.
Attorney Jenkins suggested that none of the other cases really address the issue at stake presented here, that is the interplay between the PrEP Act and the EUA. Do you agree with that?
I know there's no cases that I'm aware of that address the specific arguments that relate to the EUA as the appellants have set forth. There was a Kansas trial court. It's the MT case cited in our brief. The trial court in Kansas had briefly addressed some constitutional issues, but the Kansas appellate court then overruled that decision and held that PrEP Act immunity did apply.
Are there any cases specifically addressing the level of scrutiny to be applied on the constitutional challenge to the PrEP Act?
Not that I'm aware of, Your Honor.
Can you comment briefly on the statute that authorizes the emergency use authorization? It does have some squirrely language in there to the effect that it does require the Secretary of Health and Human Services to establish conditions on the authorization to the extent practicable, whatever that means, to ensure that individuals to whom the product is administered have the option to accept or refuse administration. The DHHS folks are supposed to create conditions on an authorization that they'll know that people have been advised of their right to turn this down. So my first question is there something lacking here in the EUA statute or what the Secretary did?
I don't believe there's anything lacking that the Secretary did. I think the section that the appellants have relied on, our position, as I think we had stated in the brief, is that's only an obligation on the Secretary. That does not impose obligations on any of the appellees. In this case, there is attached to the notice of claim at page 33 of the appendix, the consent form that was provided. So I think, excuse me, there's an allegation in the notice of claim clearly that a consent wasn't obtained. But I think to the extent that anything in the EUA statute puts an obligation on any of the appellees.
I mean, the facts that are raised here almost do amount to a willful, I mean, apparently the physician administering the vaccine was this child's actual physician, or at least based on the allegations, and they had already had a discussion with the parents about vaccinating. The parents had already refused vaccination and didn't return the consent form here, and despite all of that, they proceeded to immunize this child anyway. It's pretty egregious.
Yeah, Your Honor, and I think looking at the notice of claim, I don't think there is any allegation that this was a willful or malicious act. There's certainly, multiple allegations that go towards, excuse me, the incident in November when this allegedly occurred.
But the PrEP Act just wipes the slate clean, saying even if you did mess up on this, PrEP Act still gives you a get-out-of-jail-free card.
Well, it does to the extent that, there's a declaration that's enacted and that it's not any of the claims that could be sought through the compensation fund or through the federal court action in Washington, D.C.
That circles us back. So Congress did this. Does it fly in the face of the Constitution? And what if we reach the issue of constitutional interpretation, what standard should we use to address that? Is that the configuration of the case we're looking at right now?
I think yes. Well, yeah, I think yes. Does it provide immunity in this circumstance? And if the court addresses the constitutional piece, I'm not sure if I think the question was posed before whether that should be sent back to the trial court for review. But
Did anyone notify the U.S. Attorney General that the issue of the constitutionality of the statute was at play in this case?
not that I'm aware of, Your Honor.
So would that, if we were going to address the constitutionality of this, would it make sense to alert them, to give them the opportunity on remand to present their position on this?
I think that would make sense, Your Honor. I know there's a statute under state law that requires, notification to the Attorney General. I can't say that I know there's a specific federal statute that does the same thing, but I think it would be.
Well, there's a federal statute that says that in federal cases, you have to tell the U.S. Attorney General.
Okay, well, I was just saying I didn't know about the specific statute.
I'm unaware of a statute or a rule that says they have to be notified, the U.S. in a state case. But if we were going to look at this issue, or there was a possibility of finding that it had a constitutional concern and there was a direct attack on it, then would it behoove us to get the U.S. Attorney General notified?
I think it would, Your Honor.
And just to confirm, if we feel that we need to address the constitutional issue, I understand
Yeah, I don't believe that the Superior Court addressed, had any analysis in its order as to the constitutionality. It sort of, relied on the canon of constitutional avoidance and some other cases that have proceeded in the same fashion.
Well, if it's a rational basis analysis, then we can come up with any reason on our own. And so if we accepted all the allegations as true, there'd be less of a, there wouldn't be a factual dispute at that point to support a remand for the purpose of fact-finding, would there?
No, it would just be purely a legal issue.
And that's the case with respect to a strict standard as well.
Right.
At page 23 of the appendix, the notice of claim contains a paragraph indicating that the physician made a phone call to the child's parents later and requested that the child continue with booster shots. Does that call reflect back on the injection and suggest that the administration of the injection without parental consent was willful?
Is this paragraph 26 that you're looking at?
Paragraph
Your Honor?
26, yes.
I don't see it as that, Your Honor, but I think if the court construed that as an allegation as to willfulness, I think the result of that would, I guess backing up to the statute, the PrEP Act has claims that involve willful misconduct.
Well, doesn't it both have to be willful misconduct and it has to be serious physical injury? Don't you have to
get
have
the-
both under the statute to recover?
Under the, to
Correct.
proceed to the federal court?
Yes.
Yes.
So even if it was willful, then if there's no death or serious physical injury, there still wouldn't, liability, there wouldn't be any liability.
Correct.
There don't appear to be additional questions. Thank you, counsel.
Thank you.
And Attorney Jenkins, I believe you reserve 3 minutes for rebuttal.
Yes, Your Honor, thank you. I'd just like to revisit briefly the conversation we were having about the covered countermeasure and whether that we're saying this is not a covered countermeasure. I think what as a threshold matter, this is a Pfizer COVID-19 vaccine. It's clearly the intention of the Secretary of Department of Health and Human Services that it is a covered countermeasure. It was identified as such, okay? But what we're saying is they're not entitled to immunity if consent is disregarded. That's what we're saying. And we're saying that, and we're getting to that point.
But you agree that the PrEP Act doesn't say that. You're saying that because the EUA, emergency authorization.
Use authorization.
Thank you. Sometimes acronyms mix me up. That is really saying that the right protects the right to refuse any interventions, and as a result of that is why your clients have a claim. But the language of the PrEP Act itself clearly forecloses the claim, don't you think?
I do not.
Okay.
And the reason is that the emergency use authorization statute is acknowledging that there's a right to consent or refuse. It acknowledges that right. And we're told this PrEP Act refers us out to that statute when it comes time to define covered countermeasure and what it means. So it's obviously significant, that requirement of consent. And it's not listed within the scope of the matters that are subject to the immunity. It's not specifically listed. And it's separate from administration.
Consent's not listed, but the language is very broad.
It's broad, but as Justice Scalia and Justice Ginsburg agreed, when they were looking at the ERISA statute, just because there's broad sweeping language in a statute doesn't end the analysis. You have to look at the purpose of Congress, the intent of that statute, and other extrinsic matters. And I think that's appropriate here because on the one hand, the EUA statute's trying to protect consent. On the other hand, this PrEP Act, the way it's being interpreted, is vitiating consent.
So
there's a conflict.
your point is that the EUA gives lip service to the importance of consent. And the Secretary has to come up with an informational situation where they're advised of it. And the fact that the PrEP Act refers back to the EUA, that somehow has, it's a bit nuanced argument, but that sweeps in the element of consent into the PrEP Act.
Exactly. What the appellees have said is that we're within administration. This case is about administration. PrEP Act talks about administration. Consent's a part of administration, but it's not. Look at the EUA language. May I just complete my
Finish
answer,
your
Your Honor?
sentence.
Thank you very much. If you look at the EA language, it says the option to accept or refuse administration of the product. They're two distinct things. And the Secretary in his declarations, one of which is referred to in the briefing of the appellees, never modified the definition of administration or provided one that included consent.
Thank you, counsel.
Thank you, Your Honor.
Thank you, counsel, for the argument today. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. As is also our usual practice, I understand that both of you are in front of this court for the first time, and we would ask that you come back and take the greetings of the court.